thank you for joining us. My name is Katie Perez, and I'm a Senior Associate at Scott Legal PC. Today, we're going to spend some time talking about the National Interest Waiver rules and requirements. Just a few things before we get started. Some of you may know that the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E-2 visa and has been on several different visas, including an F-1, a TN, B, and H-1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including the E-2, E-1, TN, L-1 family immigration, national interest waivers, the EB-5, extraordinary ability visas, and more. So we will continue this webinar series doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We'll send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. So this webinar will be recorded and will be available on YouTube. We will also send a link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. And if you have any questions throughout this presentation, please put them in the chat box and we will address them at the end of the presentation. So today we are lucky to have Jiyae Hwang present the first half of the webinar. Jiyae is a senior associate here at Scott Legal PC and has extensive experience processing the employment-based visas, including the NIWs. She's our resident expert on national interest waivers. In fact, she recently spoke at the AILA APAC annual conference on this very topic. So without further ado, we will get started. And Jiyae, go ahead.
Thank you, Katie. All right. Thanks, everyone, for joining us today this morning. So let's start with an overview of what is an NIW. What do we mean when we speak of National Interest Waiver? So the NIW is a green card option that can be available when the government concludes that you are coming to the US to do something that is in the national interest. And not only does the government need to find that you're coming in to do something that is in the national interest, they must also find that you're well positioned to perform this endeavor, and that on balance, it would benefit the United States to exempt the labor certification requirement for your particular case. Now, the NIW is a subset of the EB-2 employment-based green card category, but it has a much higher bar than the traditional way of employment-based green card, which is that you would get a sponsorship from a U.S. company with a job offer, and that the U.S. company would actually test the U.S. labor market to see if there is anyone else in the United States who is minimally qualified and able and willing to perform that position. And only if they cannot find this U.S. Person, they can go ahead and sponsor a foreign national for a green card. Now, that is called the ordinary process of labor certification. But if you can prove that your case merits an NIW, you're exempt from that. So you do not need a job offer. You do not need a U.S. company to sponsor you. As a result, it kind of results in a fast track process for the green card because the foreign national can actually self-sponsor, self-petition for a green card under this category. This is why it is a very attractive option for a lot of people. Very popular choice among individuals who wish to self-petition for a variety of reasons. EB-1A is another category of the extraordinary ability green card that allows self-petitioning by a foreign national without a U.S. Sponsor, without a U.S. Job offer. But compared to the EB-1A, the EB-2 NIW can be a more viable option for a wider variety of professionals because you don't need to show that you have reached the very, very top of your field and one of the small percentage who have received sustained national or international acclaim. The NIW has a different set of eligibility criteria, which we will go through in more detail. Now, NIW to be approved for a green card under the NIW category, you do need to meet a three-prong requirement test, which is based on a recent AAO case. It is called Matter of Dhanasar. And you must also meet the EB2 threshold requirement, which is that you must either be a advanced degree professional, which is defined as someone who has a master's degree in your field, or the equivalent of a master's degree, which can be met by having a bachelor's degree in your field, and 5 or more years of progressive work experience following the attainment of your bachelor's degree, or someone of exceptional ability. Now, exceptional ability is different from extraordinary ability. It is a bit of a lower standard, and there are different evidentiary criteria that you should meet in order to show that you have exceptional ability, and we will go into more detail on the following slides. And as I mentioned earlier, you do not need an employer to apply for a national interest waiver. You do not need a U.S. company to sponsor the petition. So the waiver relates to the EB2 requirement to prove that an employer cannot find a qualified U.S. worker, which is called a perm labor certification requirement. And the challenge for NIW cases is proving why your case merits this exemption from this ordinary requirements of a job offer and labor certification in the national interest. One final point to emphasize before we go on to the next slide is that applicants in any field can apply. And really, a misconception that many people may have is that, oh, the NIW is only for STEM fields, the NIW is only for engineers. And emphatically, that is not true. We have gotten NIW approvals for a wide variety. Many entrepreneurs who have a wide variety of projects going on. As an example, we had an approval for an entrepreneur who was really focused on revitalizing a rural community with a significant investment, and that was also found to have national importance. So definitely, the NIW is not a category limited to scientists. We've also had legal professionals be approved for an NIW who could nevertheless show that their work would not only provide good services to their clients, but would actually improve best practices in the field as a whole, improve the legal field with a novel methodology, and that their insights will be shared to others through a variety of means. So definitely, it is not the applicant's field that is important, but it is more like what is the prospective impact of the applicant's work in that field. So what is important is what are you going to do in your field as opposed to what field are you in. Similarly, just because someone is an engineer or just because someone is working in the field of AI, for example, that doesn't necessarily mean that all of these applicants will be a great candidate for an NIW. If your work is only limited to, serving the interest of one particular employer or generating private profits for one particular employer or its clients, that kind of localized benefit, private benefit, may not be enough to meet the high standards for national importance. And we'll go into a little bit more detail on what that means in practice. Okay. So now let's go into a little bit more detail about the threshold requirements, and then we'll also go through the Matter of Dhanasar three-prong test, but let's start with the threshold requirements. So in order to qualify for an EB2 NIW green card pathway, you need to first meet the EB2 threshold requirements for that category. So either you need to show that you have an advanced degree, which is defined as a master's degree or higher, and the other way to be considered advanced degree professional is that if you can show that you have a bachelor's degree in your field plus 5 years of post-baccalaureate progressive work experience in the profession. And the alternative to all of that is even if you don't have a bachelor's, even if you don't have a master's, if you can show that you have exceptional ability in the sciences, arts, or business, that can be another way you can meet the EB2 threshold. Now, let's talk a little bit more detail about what each of these means. So when we say a bachelor's degree plus 5 years of post-baccalaureate progressive work experience, it is important to note that the work experience must be progressive. So if you stayed in the same position for the 5 years, if your duties stayed the same, unfortunately, that would not be enough to be considered progressive work experience. To prove that you have 5 years of progressive work experience, you will need to get detailed letters from your previous employers, not only talking about how long you've stayed at that particular company, and how long you've worked, but also how your duties have changed from more junior duties to more complex, more senior duties, how you took on more responsibilities as time went on, such that there was this increase in seniority and responsibility during the relevant time period. So definitely, it is important to be able to substantiate the progressive nature of how your work has changed. Another thing to note, and USCIS has been focusing a little bit more on this particular aspect, is the work experience must relate to the degree, and the degree must also relate to the proposed endeavor. So you can't try to qualify, right, for the EB2 threshold with an advanced degree in engineering and provide a proposed endeavor that you would open a bakery. And that is one example that the USCIS cites in the new policy manual that was announced in 2025. So definitely everything should be aligned with the proposed endeavor. Definitely there should be a direct correlation of the nature of the degree, the work experience, if you're using the work experience, and the proposed endeavor itself. Now, if you are trying to qualify with a foreign degree, it is very, very important to accompany the petition with a U.S. education equivalency report from an agency that confirms that your foreign degree, a non-US institution, is in fact equivalent to the same level degree in the US context. So, for example, certain master's degrees may actually be evaluated to be a bachelor's degree level. In that case, you may need to, go the extra step of seeing if you have 5 years of progressive work experience that you can use to supplement that, because you need that to qualify as an advanced degree professional. So it is very important to do this work in advance, see if your foreign degree is in fact equivalent, because to avoid surprises later. Now, if you are trying to qualify with exceptional ability in the sciences, arts, or business, the evidence must cumulatively show that you have a degree of expertise that is significantly above what is ordinarily encountered in your field. And the way to prove that is you also need to show at least 3 out of the 7 criteria that is listed here, such as any degree or diploma related to your profession, an area of exceptional ability, letters documenting at least 10 years of full-time work experience in your occupation, license, having commanded a high salary, membership in relevant professional associations, and importantly, evidence of having been recognized for your achievements and significant contributions to your industry by your peers, government entities, professional or business organizations, or other comparable evidence of eligibility. And it is important to note that the totality of the evidence must tend to show that you do have that degree of expertise that is significantly above what is ordinarily encountered. So there is a bit of a qualitative assessment in this aspect as well. And keep in mind that the area of exceptional ability that you prove must also be directly related to your proposed endeavor. All right, so now let's move into the three-prong Matter of Dhanasar test, and I will go over each criteria and discuss in more detail what each criteria means. So, what are the three-prong NIW requirements? So the first prong that an applicant must meet is to show that an applicant's proposed endeavor has substantial merit and national importance. And let's get into a little bit more detail on what this really means. So step 1 in the NIW process, and I would say it is a very important um, framework that defines the case, is to clearly define the endeavor. What is your proposed endeavor? And what a lot of people may not realize is that the proposed endeavor must be specific. It must be more specific than simply proposing to work in an occupation. So if you're an engineer, for example, and if your proposed endeavor is just one sentence and you explain, I will work as an AI engineer at Google. And if that's it, then unfortunately, that is not enough to count as a proposed endeavor for NIW purposes. By contrast, if you go into more detail about what you're doing as an engineer. So, for example, maybe you are participating in a research project that is seeking to develop a more cost efficient and more effective way to train a particular type of AI model. And maybe you're working in partnership with XYZ University or XYZ company, and you're working to develop this technology, and you can present practical interest in this particular project that you're doing from US institutions. That kind of plan is definitely more detailed than just saying that you'll be working as an engineer, and that kind of plan is what the government is looking for when we speak of a proposed endeavor. It is what you're proposing to do in your occupation rather than a plan to just work in an occupation. Now, another element to note is that geographic scope is not the focus anymore after Matter of Dhanasar. So you actually do not need to show that your work will physically touch all 50 states in the United States. It is sufficient if you can show that your work will have a national or globally significant impact to the field. Within a particular field, uh, no matter how your physical scope of endeavor is. So let's talk about some examples: improve manufacturing processes or medical advances, or substantial positive economic effects can be considered to have national importance regardless of the actual physical scope of the endeavor. So when we speak of substantial positive economic effects, some projects are really focused on revitalizing a very particular economically depressed region in the United States. Let's say a particular rural area, for example, and maybe your project will have a very significant impact in revitalizing that region. Then that endeavor can have national importance, even if the geographic scope of the endeavor is limited to that region that is economically underdeveloped. So definitely, there is a wider variety of endeavors that can qualify under this new standard. The benefit. It is important to be able to convince the USCIS that the benefit of your endeavor will go beyond one's immediate employer or clients, but will have a broader impact to the field. And talking about medical advances, for example, right? If you work as an employee of a particular research university or research hospital, and if you develop a new cure for a difficult and complex disease, it is not just this particular hospital that will benefit from this new cure. All of the patients in many different hospitals around the US will be able to benchmark this practice and also apply this particular cure to, improve the lives of their patients and improve treatment outcomes. And so that will have the type of broad impact that the government is really looking for when we're speaking of a broad impact to the field. Not only will it benefit your immediate employer, but it will result in an advancement in the field that will impact others as well in the field. Similarly, let's say that you are someone who's developing the industry's first foldable phone. And if the industry's first foldable phone is developed, many other companies will scramble to also, do a similar R&D project to release their foldable phones. And in that part, you will be pushing the envelope for the entire competitive industry. So that kind of impactful project at the forefront of an industry can also be used to try to support the claim of a broad impact to the field, not only benefiting the private bottom line of your immediate employer. Now, substantial merit and national importance are a little bit of a different concepts. Substantial merit is the easier standard, but you must be able to show that your endeavor has both substantial merit and national importance to be able to meet this first prong. National importance does focus on the larger scale and broader impact of the endeavor itself. It is not relevant to the geographic scope, but it is related to the scale of the impact it may have and whether it goes beyond your immediate employer. A couple of misconceptions to correct here. So there is a misconception that if a particular field has a job shortage in the US, then everyone will be approved for an NIW if they're working in that field. That is a misconception. And Very commonly people were talking about pilots and whether any pilot can be approved for an NIW because there is a shortage of pilots in the US, and that argument has been debunked. It will not be successful. It is not the field that you're working in that is important, but what the impact of your work will be in your field. So if you're a pilot, a researcher of pilots, that you're developing a new way of training pilots that will be, implemented by so many different piloting agencies. Maybe that can be one way to provide a broad impact, but just by saying that you will be working as a pilot and the US has a shortage of pilots will definitely not work for the national importance argument. Similarly, the nature of the proposed endeavor is also very important when we speak of national importance. There are many AO cases that hold that teaching is a type of endeavor that tends to only benefit the immediate students who are benefiting from that teaching. So if you wish to apply for an NIW, and if some of your work relates to teaching, you may want to explore whether there are any other aspects of your endeavor that goes beyond teaching, just benefiting your immediate students. So, for example, if you're a professor, and part of your duties may be teaching, but if part of your duties involve research and publication of this research, and presenting your new research findings to other experts in the field, maybe that can be found to have a broader impact rather than just limited to the activity of teaching. So the way that you present your endeavor can also be very important on the strength of your national importance claim. All right, now the second prong of the Matter of Dhanasar test is to be able to show that the applicant is well positioned to advance the endeavor. And here, the focus is on the individual. The USCIS will look at the background of the person with regards to the professional experience and education that is relevant to the proposed endeavor. The USCIS is really looking for a track record of success and influence in the field. Any information about previous projects that the person has done that is relevant to the proposed endeavor would be relevant in this inquiry. If the applicant has published patents or intellectual property in the past, that can be a very helpful type of evidence for supporting a well-positioned claim. Because that shows that the person has already made innovations in the field that may have been cited by others, that may have been used or licensed by others. So that kind of track record of influence can be very helpful. Another question to ask is how far along is the proposed endeavor? So if, the applicant is already in the United States, maybe they are already developing the business on an E2 visa. Maybe they have a prototype that they commercialized. Maybe there is evidence of industry interest in the form of, for example, incubator admissions, accelerator admissions, or maybe you receive investment into your particular project by a venture capital fund, things like that. That shows that the endeavor is already in its way to proceed. That kind of evidence can also be a powerful help for meeting the second prong, that you're well positioned to advance the endeavor because you have led the endeavor up to that point of having that progress. Similarly, if the business already exists in the US and if you have a different work authorization, such as E2 or O1, or even, OPT, if you're running this company and can provide evidence of contracts with clients or business partners, if you have tax returns showing that the company has already made significant revenues, profits, and U.S. hiring, Forms W-2, for example, for employees that your business already has, those kinds of business-related metrics. Objective evidence of business performance metrics can also be helpful on proving that you are well positioned to advance your endeavor, and also maybe to substantiate some of the claims of national importance as well. Now, the third and last prong for the Matter of Dhanasar test is that the petition, on balance, must show that it must be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification, looking at the petition as a whole. So there are a variety of different ways you can argue the third prong. You can maybe bring in some extraordinary ability considerations. If you've received awards in your field, if you've judged the work of others in your field, if you are a member of prestigious organizations that require exceptional, extraordinary achievements, you can maybe use some of those type of evidences um, to point to the fact that your expertise is special, it is not very replaceable, and that it will benefit the US to have you in this position and to share your expertise rather than to force, a replacement with someone who only has minimum credentials. You can draw evidence from prong one and prong two. So from prong one, if you have evidence that your work will have a broad impact to the field, you can use that to show that the large scale benefits of your work will definitely outweigh the ordinary benefits of the labor certification program, which is to save one job spot for, a US worker. You can also point to evidence from prong two that you used that speak to your unique experience and unique expertise. If you can show that particularly some of your skills will be very hard to replace, maybe that can be used in support of the argument that, it would be beneficial for the United States to get their hands on this particular set of skills rather than having them be replaced and risk not having access to those very special skills in the field. Entrepreneurs also have a couple of arguments that they may be able to use. So one argument is that entrepreneurs are self-employed and they're often not eligible for green cards under the traditional labor certification requirements because they have majority interest. Many of them have majority interest in their companies. You can use that as part of the balancing inquiry. And so, on balance, entrepreneurs can use this fact to show that it is beneficial to waive the requirement of the job offer and labor certification, such that they are given this opportunity to more permanently make a difference in the United States. So, the final note here is that Matter of Dhanasar specifically notes that entrepreneurial work can lead to an NIW and even states that this planned venture does not need to ultimately succeed as long as the applicant can show that it is more likely than not to succeed. All right, now let's move on and talk into a little bit more detail about the national importance prong, the national importance aspect of the Matter of Dhanasar prongs, which tends to be very strictly scrutinized by USCIS in recent years. So let's talk about national importance. A couple of points to emphasize here. The applicant needs to prove the importance of the applicant's specific proposed endeavor, and really the inquiry is not hinging on the importance of the field or occupation the individual will be working in. So not only does the applicant need to say, that they're working as an engineer, for example, that cannot be the end all be all of the proposed endeavor. You need to show what you will be doing as an engineer and how that will impact the field of engineering. Expert letters can be an important strategy when making the national importance argument. If you can get persuasive expert letters from a relevant government agency, for example, let's say you are someone who's working in energy and you can get a letter from someone who's working at the Department of Energy that is a directly relevant US government institution. If that representative can talk about what your specific project is and what are the expected impacts of your project within the field of energy and how that's important. If you can get expert letters to really give that support, that can be a very powerful narrative that can guide the USCIS officer and help convince why this particular endeavor will be impactful. Expert letters can be very helpful because if you only rely on reports and media articles about the industry itself, there is no direct link to what you are doing in your field. So experts can help fill this gap and talk about what are the limitations the field is seeing right now and what will your project do to advance this field. And Objective letters can be very helpful from people who have not worked with you in the past, but is nevertheless an expert in the industry who can talk about the, needs of the industry and the expected impact of your work. And also, you can get letters from people who are familiar with your work and have worked with you before, and can talk about the impact of your previous endeavors that are related to the current proposed endeavor. So expert letters can play a very important role in, filling the gap in the proof of the expected impact of your work. Benefits to one specific employer alone will usually not be enough to meet the national importance standard. So it is very important to work with a lawyer who can help you develop what kinds of other evidences can we point to try and prove that the benefit goes beyond just benefiting your specific employer or your specific, set of clients that you immediately work with. Broader impacts to a field of region or the public at large. That is one of the operative languages that you want to aim for when you're thinking of national importance. So here are some examples of endeavors that can be shown to have national importance. A person developing a drug for a pharmaceutical company may establish national importance by demonstrating the prospective public health benefits of the drug, instead of solely projecting the profits that will accrue to the employer. Similarly, widespread interest in adapting or licensing a technology, a novel and important manufacturing process, or how the technology stands to impact the development of similar technology by other companies can be used to show a broader impact to the field, a region, or to the public at large. So those are some examples that you can keep in mind when you're trying to think of what are some of the arguments you may be able to make for national importance. Finally, substantial economic benefit and creation of U.S. jobs at a level significant with respect to a population or economy of a region can be used as an argument to support national importance. And for an example, we got an NIW approval with our RFE for an entrepreneur whose project was really focused on generating a high number of jobs. And we're not talking about just a dozen jobs. We're talking about very, very high number, hundreds of jobs in a region that was economically underdeveloped. That petition was approved. The scale of the economic impact was found by USCIS to be significant in that particular case. Really, though, it is a factual assessment that you would do. It will really need to be significant with respect to the circumstances of a particular region. So a nuanced approach is recommended here. All right, so now I think at this point I will hand it over to Katie, who will take us through the rest of the topics.
All right, thank you, Jiyae. So we are going to build off of what Jiyae has already shared a little bit and discuss now what proof you would need to meet the threshold requirements. So as Jiyae mentioned, the first step in the National Interest Waiver submission is showing that you meet one of the threshold requirements. So in other words, showing you have that advanced degree, master's degree or higher, or a bachelor's degree in 5 years of progressive work experience in the profession, or meet at least 3 of the criteria she previously listed. So if you're going to qualify on your advanced degree, you would want to submit a copy of your diploma and the transcripts. If you're going to qualify based on that bachelor's degree in the 5 years of progressive work experience, you'll still need to show that you've been awarded that bachelor's degree by showing the diploma, and then also proof of the 5 years of the progressive work experience. So you can show that progressive work experience through a detailed letter from your past employers that not only confirms that you worked for the employer, but then also describes that you had a full-time job. It describes your duties, responsibilities, and describes how those duties have changed over time to include the more senior and more complex duties and responsibilities. So it'd be important to document that progressive 5 years with an official letter from the company you previously worked at. So I know Jiyae also mentioned this too, but as a note, if your degree was earned outside the US, it is very important to get that academic equivalency report. And that report will explain to the US government that your degree is equivalent to, say, the bachelor's degree or the advanced degree. And also, as she mentioned too, obtaining that equivalency report before you file. That way you can potentially avoid an RFE or the government saying, your degree is not equivalent to a master's, something like that. So for the exceptionability, if you're using that to meet the EB2 threshold requirement, the supporting evidence will really depend on which criteria you think you can satisfy. I'm not going to repeat each of them there that GA already stated, but as an example, if you have that 10 years of full-time experience in the occupation, you would want to obtain those official letters from your previous employers documenting the 10 years of work. The letters should describe your position, your title, how long you worked at the company, um, that detailed sort of information. Similarly, if you had a license to practice your profession, you would want to obtain a copy of that license as the supporting evidence for the petition. Regarding the exceptional ability criteria, we would always try to meet as many as possible. Um, excuse me, just in case USCIS comes back and says, hey, you only meet 2 of the criteria, not 3, and having others to fall back on can potentially avoid the request for evidence from the government. So if possible, it would be recommended to provide more than 3 criteria. So after meeting that threshold requirement, you do need to provide evidence that you qualify for the National Interest Waiver, which, as she also mentioned, was the 3 criteria from the Matter of Dhanasar. So the first was that proposed endeavor has substantial merit and national importance. Second, that you are well positioned to advance that endeavor. And third, that on balance, waiving that job offer and labor certification is beneficial to the U.S. So we'll walk through a few examples of the types of supporting evidence you can use for that NIW petition and why they matter. A strong NIW case can typically has a comprehensive business plan or a detailed statement for that proposed endeavor. This document must clearly articulate why you intend to do articulate you what you intend to do in the U.S. and how it goes beyond just simply working in the general field. So USCIS will rely heavily on the description you provide in this statement because it does become kind of this foundation for them to evaluate whether your proposed endeavor has that substantial merit and national importance under the Matter of Dhanasar framework. So this letter and the business plan can really help show USCIS that your proposed work has the inherent value and can have this national this impact is national in scope, not just local, and goes beyond your clients or just your employer. Also to demonstrate like the national importance, you may need to provide some contextual evidence. For example, you may want to provide some government reports, news articles, or academic papers showing that the area you plan to impact is recognized as deficient or needing advancement. The sources can help show why your work matters, but it is important to be strategic about these reports if you're going to provide them and selective because the evidence must tie directly and specifically to your project. So broad evidence about the importance of the field as a whole is usually insufficient. It really should be related to you and all be connected. So as an example, if GA kind of mentioned the pilots, I was going to say engineers, but um, if you are showing that there's a shortage of engineers, that by itself may not show, the national importance of your proposed endeavor if you're just planning to get a job and work in that field. Even if you submitted articles showing like the industry has a shortage overall, you really do need to show that broader impact. So not just simply performing the duties of an engineer, USCIS is really looking for that direct relevance between the evidence and your specific endeavor. Um, so this is also why expert letters can also be really valuable. Well-crafted expert letters can speak directly to your proposed endeavor, explaining not only what you intend to do, but also why your particular project has that potential to advance the field in a meaningful way or provide benefits. So expert letters tailored to your work can be a powerful way to substantiate the substantial merit, national importance of your endeavor. Those letters would really want to be from people in your field who are experts and, again, just connecting all the dots for the government. So the overall goal would be to build this petition and making sure the evidence connects. Maybe you have the business plan, the third-party articles, expert letters showing this cohesive, specific picture of why your proposed endeavor warrants this national interest waiver. So again, for let's see, addressing the well-positioned to advance the endeavor prong, You would want to provide evidence demonstrating that you have the skills, background, momentum needed to successfully carry out the proposed work. This includes a variety of materials that collectively show your capacity and future potential. A strong starting point could be your resume, along with documentation of past professional accomplishments, such as awards, notable achievements, certifications, or other recognitions. If you have delivered presentations at conferences, contribute insights to professional audiences, or otherwise shared publicly your expertise, those accomplishments may help establish that you're already viewed as influential in the field. Demonstrating that past influence can support USCIS's finding that your future work is also likely to be impactful. You could also provide evidence related to industry and media recognition. This can also carry considerable weight. So, for example, if you're an entrepreneur who founded a company that has attracted attention from industry associations, venture capital firms, media outlets, that sort of thing, that recognition can be used to show influence, your credibility, and early stage impacts. Those indicators can help elevate your profile, demonstrate that you are well positioned to advance your proposed endeavor. Um, and again, this is especially valuable for individuals working in more non-traditional or emerging fields where conventional forms of evidence may not be available. For the entrepreneurs in particular, um, a range of evidence can help strengthen your petition. Evidence and examples could include contracts or agreements with major organizations or in the relevant industry. You could provide letters of intent indicating future partnerships or commitments, evidence of significant startup capital, again, grants and investor support connected to this business endeavor. These materials can help show that you have not only a viable plan, but also you've secured the resources, the partnerships, you have that market traction necessary to advance your proposed work. So again, together, these types of evidence can paint that compelling picture that you're well positioned to successfully carry out and continue advancing your endeavor in the U.S. So when you're considering the evidence, this is really an area where you may want to be a little bit more creative and be your best advocate. Even if you have an attorney, you're in the best position to really understand your experience because you're most familiar with what really exists. If there is a newspaper article written about your work, it may be hard for your lawyer to be aware of this. So it would be helpful for you to bring this to their attention. Your lawyer can, of course, help you strategize and discuss what type of evidence would be best and help you support your petition. But if you have that article written about you, you can bring it to your lawyer's attention. They can help you understand whether or not it would be helpful to support your case. Similarly, if you had received a grant or funding for your work, um, your lawyer could help you strategize to understand whether or not those documents and evidence would help support your petition. Regarding how to demonstrate that waiving that job offer and labor certification benefits the U.S., again, you would really want to reiterate the evidence from prong 1 and 2 and really emphasize that the value of your work to the U.S. is so significant that waiving the requirements does really serve the national interest. Um, so, for example, maybe you're working on problems tied to national competitiveness, national security, or critical U.S. priorities, maybe things of energy, health, AI, that sort of thing. So, you would want to emphasize that granting that NIW does better serve the national interest because of the benefits of your proposed endeavor outweigh the protections offered by that job offer and labor certification requirement. Okay, so now we will discuss a little bit the recent trends and strategies within the National Interest Waiver petitions. So in the past couple of years, there has been a significant increase in the number of the NIW applications filed. And along with that increase, we've also seen a rise in the requests for evidence, the RFEs and denials. Our sense is that USCIS has been scrutinizing those petitions more closely. As Jiyae had said, last year USCIS came out with new policy memos, so they have been scrutinizing more the national importance requirement. So as a result, obtaining that NIW today is generally more challenging than it may have been a year and a half ago. But that said, despite the heightened scrutiny, many NIW cases are still being approved, and it can still be a viable pathway for people wanting to pursue the green card. It is important to remember that past approval trends doesn't guarantee the future approval, but it does help to illustrate what kinds of cases can succeed when they're properly prepared or well supported. So here under the third point, the government has issued policy guidance that's clarified several national interest waiver aspects. Again, so back January 2025, USCIS did update the policy guidance on how it evaluates national importance, including the types of evidence that can demonstrate that broad national impact. So occasionally we do see changes in how USCIS does treat the cases. As another example of how adjudications can shift, during the prior administration, the federal government did publicly emphasize the fields like science, technology, engineering, mathematics, STEM were of particular national importance. The White House even had publications that people often included for their NIW filings to support the national importance of these STEM-related fields. But under the current administration, we're not really seeing those same type of federal publications reaffirming the STEM priorities. But even so, the absence of the new public statements doesn't mean those arguments are no longer viable. We can and still do see people make strong arguments about the ongoing national importance of science, medicine, engineering, technology, and those related fields. So with, sorry. So really, while the environment for NIW applications is more demanding, but a well-documented, well-tailored petition supported by the evidence can still be approved. So we will talk a little bit about the entrepreneur-specific strategies. I kind of touched upon these in the previous slide, but ways to demonstrate the substantial merit or national importance can be supported by significant media attention on the petitioner, the business, or both. You could provide awards, grants from government entities, letters from third-party industry actors like investors, the venture capitalists. You could provide letters from other government agencies, evidence of your revenue generation, growth, job creation, that sort of thing. The dissemination of results through conferences, patents, licensing, that sort of thing. In order to help demonstrate well-positioned for an entrepreneur, you could provide evidence that you have ownership and a critical role within a U.S. entity, your degrees, certifications, letters describing your experience, evidence of investment interests, incubator and accelerator participation, receipt of the government grants, intellectual property by applicant or your company, media attention, revenue growth, or letter from third-party reviewers. Okay, so we'll go on to the next slide. So we'll discuss a little bit about timing and the considerations. So there are some strategic considerations you'd want to think about when transitioning from the non-immigrant visa to the NIW green card. It's important to understand that applying for the green card involves two separate steps. First is the I-140. This is the core of the NIW process. The I-140 is the underlying immigrant visa petition where you must demonstrate to USCIS that you qualify for that NIW category. This is the stage where USCIS will evaluate whether your proposed endeavor has substantial merit and national importance and whether you're well positioned to advance it. So within the I-140, USCIS does offer what they call premium processing for the NIW I-140s. The fee is about $3,000, and the premium processing will guarantee a decision within 45 business days. This will significantly accelerate the I-140 stage. Without that premium processing, the USCIS adjudications for the I-140 can be anywhere from 6 months to 12 months or longer. So it is important to note that the premium processing only speeds up the I-140 decision. It doesn't guarantee or accelerate the green card approval itself. So once your I-140 is approved, you can move on to the second step, which would be to obtain the green card. And then from there, you have two pathways. Depending on where you're physically located, you may want to think about which one to choose. If you're in the US, you may apply for what is called the adjustment of status on the Form I-485 with USCIS. If you're outside the US, you may want to apply for the immigrant visa with the Department of State. So after your visa interview and approval, you would then enter the US to become that permanent resident upon your admission. So whether you receive your green card quickly or wait months and years kind of depends on the visa bulletin, which is a monthly publication showing availability of those immigrant visa numbers in each category. For the NIW applicants, you would be in the EB2 employment-based preference category. To determine when you can apply for that green card, you would check the visa bulletin each month. You could look up the EB2 category, your country of birth, and see whether there is a wait time. You would monitor your priority date, which is the date you file your I-140, and then wait for your priority date to become current before you can apply for that green card. So another important consideration when you're thinking about applying for a green card would be your underlying non-immigrant visa status. So when you file for that NIW petition, you are filing an immigrant petition which signals to the U.S. government that you intend to immigrate to the U.S. In the near future. So this does matter because for certain non-immigrant visa categories, the government can be very strict about your intent. So certain visa categories, your intent should not be to stay in the U.S. permanently. So for example, if you're in the U.S. on a TN visa, and your TN visa is going to expire soon, you may want to renew that TN visa before you file for the NIW. Structuring the timing in this way can help preserve your non-immigrant status for as long as possible. So once that immigrant visa or petition is filed, the TN renewal can become more challenging because officers may question whether you still qualify for that visa category that requires no immigrant intent. So by contrast, there are some visa categories like the H-1B and the L visa. These are called dual intent visas, meaning it is acceptable to pursue permanent residency while holding those statuses. Filing the NIW petition doesn't necessarily jeopardize your eligibility for those visas. So it is important to try to maintain that underlying non-immigrant visa status, whether you have an E2 or a TN or another category. You would want to have enough validity remaining on those visas before you file that I-140. And then again, just maintaining your non-immigrant visa status throughout that NIW process does help ensure stability while your petition is pending and can help minimize the risks associated with being in a period of authorized stay if you don't have a non-immigrant status and you filed your 485. So that I-140 does not provide you with immigrant status. So even if your I-140 was approved and you file for the I-485, you're not placed in a formal non-immigrant or immigrant status. You're just in what they call a period of authorized stay. Historically, individuals in this situation where they filed that 485 have not encountered issues with the government or government agencies like ICE. However, we are in more of an enforcement era with this current administration. So again, that would be a reason we would recommend trying to maintain your underlying visa status as long as possible. So is the EB2 category current? So this month, USCIS is using what they call the dates for filing chart. The EB2 is current on the dates for filing chart for, excuse me, for March for all chargeability areas, all countries except India and China. So you may be able to file this month because they're using the dates for filing charts, but it doesn't necessarily mean that you're could be approved for the green card yet because you would still need your final action date shown for your country to be current. So right now they are using the dates for filing chart, which means you could file your I-485 if you're otherwise eligible depending on your country. And then from there, you could also file for that employment authorization and travel documents. So right now, the final action dates do remain backlogged for a lot of countries, especially India and China. Again, meaning that you may not be able to get approval for a while for many people in the EB2 group, unfortunately. So some pros and cons of adjusting status in the U.S. Versus consular processing. The decision to adjust within the U.S. or pursue the consular processing abroad may depend really on your own individual circumstances and your travel needs while that NIW is pending. So consular processing can be advantageous if because it reduces the risk of complications for people who may hold those temporary visas or need to enter and exit the U.S. Multiple times while you're going through this green card process. So when you choose the consular processing, you can generally continue to use your underlying non-immigrant visa like the TN or the E2 because you're not signaling your immediate intent to remain in the U.S. and adjust your status. Instead, you're planning to attend the immigrant visa interview with the consulate. So for many applicants who need to travel or have other restrictions, the consular processing may be the route that they prefer. Adjustment of status can be a good option for individuals in the right circumstances. So if you're already in the U.S., pursuing the adjustment of status may be an option you prefer. So maybe you don't need to travel immediately or that often, or you already have family here. If you have a lot of time remaining on your non-immigrant visa, maybe that's a reason why you decide to pursue the adjustment of status. So if you are in the U.S., again, filing for that 485, the adjustment of status, you can also apply for the work permit and the travel authorization. But just as a note, it does take a while for the government to approve these travel documents. It can take 6 to 9 months or longer. So if you have filed for the 485, you do need to remain in the U.S. until that travel document is approved, unless you have one of those dual intent underlying non-immigrant visas like the H or the L. So the restrictions with the I-485, the adjustment of status filing while you're in the U.S. may be a reason you don't want to pursue adjustment of status in the U.S. because it may prevent you from traveling abroad if you need to for work or family or something like that. Really, the consideration of adjustment of status or the consular processing would probably be something you'd want to discuss with your attorney in more detail just based on your own individual circumstances. Go to the next. Okay, so we do have a case study. We can go through it quickly. So here the applicant was an entrepreneur who formed a small consulting firm focused on improving services for U.S. veterans. Regarding the substantial merit and national importance, the applicant submitted expert letters, news and media articles, research reports, the government initiatives. The documents were supporting the difficulties faced by returning veterans from Iraq and Afghanistan and showed the value and the importance of providing these services to the veterans. There is a business plan which described the limitations of the existing programs and discussed specific plans to improve the services for U.S. veterans, sorry. Under the well positioned, the applicants provided letters again from government officials, business leaders, industry experts attesting to his prior success organizing veteran reintegration programs, which did result in millions of dollars being executed in charitable funding. There was the comprehensive business plan again outlining his planned activities, that sort of evidence. Just quickly on balance. It was shown as a self-employed entrepreneur, it would have been impractical for the applicant to obtain this later labor certification. Additionally, the demonstrated value of the services he planned to provide and his track record of success in the field meant that even if other U.S. workers were qualified to provide these services, the U.S. would still benefit from his contributions. So this case study really is just important because it does show that there's a wide variety of proposed endeavors that can qualify for the green card under the National Interest Waiver. So even if you're a small consulting firm, as long as you can show that broader impact to improving the best practices in the field, it doesn't really matter what the field is. It is just really connecting those dots for the government to see that you qualify for this national interest waiver. So like in this case, it was for veterans welfare. So if you can show that there is a particular limitation in the field that you are working in, and you can show that your proposed endeavor will have this broad impact on improving the best practices in the field as a whole, as opposed to just providing, good services for one particular employer or a few clients, then, you may be able to qualify for the NIW as well. It would just be a matter of, looking at different strategies to show that the broad impact and the future impacts. So I don't know if we'll have any questions. I'll go to
Yeah, thank you, Katie,
quickly.
for sharing your insights. I don't think we have any questions that came in. Maybe we'll give another 30 seconds to see if
Okay.
anyone wants to um, submit something in the last minute, but otherwise, I think we've covered everything.
Hmm. All right. Well, thank you, Jiyae.
All right. Well, thank you so much, Katie, for your expertise. I don't think
Sounds
we
good.
have any questions that came in, but if anyone who's participating would like to discuss your particular case or questions further detail, definitely follow the links that we will share to schedule a consultation with any of us. And I hope to see you at the next webinar.
Bye.
Bye.